The key is to identify weaknesses in the government's case. You attack the key witnesses for the prosecution whenever possible, whether they have motive, bias, any impeachment that you can bring out as far as prior convictions, inconsistent actions or statements, any inconsistencies with the other evidence in the case, particularly any scientific evidence. Focus on those things. Focus on the failure of the prosecution to establish the elements of the offenses charged. Break those elements down and attack wherever their case is weak. Has the prosecution presented sufficient evidence of your client's mental state, the mens rea for the required element of the crime that's been charged? Has the evidence of requisite actions been presented in a provable manner? The ultimate key to everything in a criminal case is whether the government has failed to meet their burden of proving your client guilty beyond a reasonable doubt, whether they have met the burden as to proving each and every element of the offenses with which your client is charged. The presumption of innocence is the primary weapon in every defense attorney's arsenal. Use it constantly, bring it home each and every time. Affirmative defenses may come into play as well, depending on what the focus of your case is. This is a critical part of your argument if your case involves an affirmative defense, whether it's self-defense, entrapment, a mental health defense such as insanity, necessity, compulsion. Any of these or others that exist out there, you have to be very particular as to your presentation in this regard, since you have the burden of proof as to those affirmative defenses which you have alleged. You have to present evidence to the jury, present a compelling argument to the jury that they will find that that affirmative defense exists, that either lessens the impact of the crime with which your client is charged with or even acquits him.